There are some parents out there that can't stand their children, and they want their last act on this earth to let their children know that they detest them. How do they do this? By drafting a will that states that they intend to leave nothing to their son, daughter, or all of their children. Yes, it is possible to disinherit your own children. And if you're curious about this, I will lay it out in this video. But before we do, this is the legal code, and on this channel we discuss a wide range of legal topics, whether that's to get your estate plan in order, things to look out for, legal pitfalls to avoid in your small business, or ways to protect yourself, as well as celebrity shenanigans, but only in so much as that you can have a takeaway to apply it in your life. That is always my goal whenever I do this channel, to do these videos, is that something to present information that can enrich your life or help you, or let a light bulb go off and you come up with a strategy on your own to improve whatever circumstances you're dealing with. So if you like that sort of thing and you find value in this content, please don't forget to like, subscribe, and share with anyone else you also think will find value. Also, I am a real life attorney. So if you would like the opportunity to meet with me to discuss estate planning, your small business concern, whether to copyright, whether to trademark, whatever it may be, we can sit down and troubleshoot any area that you're having some trouble with and come up with an action plan. There is a link in the description box. Now, without further ado, let's get into this topic. How and why do people disinherit their children? And this video was inspired by one of my subscribers who left a comment. I forgot her name, but she asked me to do a video about the dynamics of disinheriting your children, whether or not it's possible. So this is for you, and hopefully everyone else can have a takeaway as well. So parent and child dynamics are so complicated, and to make it even more complicated, when you throw in money into the mix, it has everyone on pins and needles, especially if there's unresolved stuff from the past or currently going on. So as it relates to inheritance, already a heavy topic and a topic that gives people anxiety, there's a lot going on, and their parent-child dynamics play out and act out in several different ways. There could be relatively healthy relationship between the parent and the the parent is totally willing to create an estate plan that includes his or her children. Or there could be a troublesome parent with maladaptive children and the parent is reticent but willing. Or there could be relatively stable parents who have a troubled child, leading to uncertainty for the parents. Or there are parents who do not trust their children due to whatever past stuff that has happened. Or there is a child suffering from a substance abuse problem, and the parent wants to leave something for their children, but is reticent because there's a concern that the child's addiction will cause them to squander their inheritance. The addiction doesn't necessarily have to be substance abuse, I should say. It can also be gambling or shopping, any sort of deleterious addiction that causes them to not be able to hold on to the money. Or there could be estrangement, no relationship at all between the child and the parent. There could be parents that vehemently disagree with their child's lifestyle choices. It could be about their sexuality, or it could be as mundane as their career path. Or there could be parents who manipulate their children with money and lord it over their heads, that they're going to disinherit their children in order to have compliance, or what the parent sees as compliance from the child, and the child bending to the whims and desires of the parent. So those are the dynamics I've thought about. If I'm leaving something out, please don't forget to include that in the comment section. But again, the idea is that there are a myriad of scenarios that play out between the parent and child. I truly believe that most parents don't want to have a contentious relationship with their child because it defies all biology, the biological urge to protect children and offspring. However, it happens for a myriad of reasons, whether it's psychological, substance abuse, or sorts of reasons it can happen. Nevertheless, you may be asking, can a parent actually do the forbidden act of disinheriting their child? Yes. he or she absolutely can and disinherit their children, and it happens all the time. But the only way to do this is through an estate plan. To disinherit a child, a parent would need to explicitly state in their will that they do not wish for them to receive their assets. You could also word it in a way that excludes any of your child's descendants, meaning you'll be disinheriting your grandchildren, your great-grandchildren, and other future generations stemming from their line. Ouch, right? In most states, it is totally legal to disinherit a child for any reason or no reason at all. However, in Louisiana is a wild card. They have what is called a forced heirship law. A child may only be partially disinherited. Louisiana is the only state where this applies, and it's based on, it's derived from Roman and French law. And the simple example of the law is that forced heirship is that there's a requirement that a portion of the person's estate must be left to his or her child, who are under law known as forced heirs. So Louisiana is the exception. But regardless of the level of disinheritance, a child may only be disinherited by a parent with capacity acting without undue influence, meaning they must be of sound mind and acting of their own free will. What's more, if the parent is disinheriting a child for some reason, that reason must be factually accurate. Also, I want to note that the right to disinherit only applies to adult children. If you have minor children, then legally you would not be able to cut them off of your will. As long as your estate has assets you leave behind, state law will dictate that those assets must be used to pay for the care and maintenance of your children. But once the child reaches the age of majority, then you can disinherit them. You may be wondering if simply omitting mentioning of a child in your will is enough to exclude them from inheriting. No. The short answer is no. Leaving an adult child out of your will alone will not be enough to legally disinherit them. Likewise, you couldn't just cross out someone's name on your existing will to keep them, to prevent them from disinheriting. You'd have to add a codicil or draft an entirely new will to ensure that your wishes are upheld. If you think simply disinheriting your child is all you have to do to get rid of them, think again. It doesn't end there. Disinherited children still have a legal right to contest your wishes. Adult children have legal rights when it comes to inheriting assets or being disinherited by parents. The exact laws may vary from state to state, but generally, disinherited children have a legal right to receive a copy of the will or trust. They may also have the right to contest a will, which is a challenge to the provisions of the will or trust, if they believe that they've been wrongfully disinherited. Children can't contest a parent's decision to disinherit them simply because they believe it unfair. There has to be a legal standing for them to contest a will or trust. For example, they may be able to dispute the terms of their parent's will if there's some evidence of undue influence, or the parent did not have the capacity to actually draft the will and was not of sound mind when the will was being created, or their will was not properly witnessed, or they suspect that they made the will under duress or under influence. I said that already. It may also be possible to contest the will or trust after being disinherited, particularly if you believe that there's a factual error resulting in your parents leaving you out. This may apply in scenarios where the disagreement is over the child having a substance abuse problem or a lifestyle choice. This is key, and the child will challenge it, saying that this is an unjustifiable reason because I don't have a substance abuse problem. Therefore, there's a error of fact. For example, if your parents disinherit you because they believe you were using illicit drugs or abusing alcohol, and you prove that you were not, then you may be able to contest the will. It all depends on the relative strengths and weakness of the case. That's why it's important to consult with a probate litigation attorney or trust litigation attorney early, so that you can help determine whether or not you have a case, if you are a child who has been disinherited, whether or not you have a valid case to challenge the will, and what the likely outcomes may be. Although it is completely permissible to contest the will, it is extremely expensive as well, costing tens of thousands of dollars. Secondly, the chances of contesting a will, I will tell you, are slim. The chances of winning are slim. Research shows that only about 0.5% to 3% of wills in the U.S. undergo contests, with most will contests ending up unsuccessful. So you will need valid grounds to contest the will, and you will need the resources to withstand the financial hit, because it's extremely expensive for the average person. Alternatively, failure to not have a will or a comprehensive estate plan means that the person dies intestate, which will only result in the estate being probated, which in any case, the children, once they prove that they are the rightful heirs, will inherit, albeit with a headache. The probate court process will distribute assets to someone's heirs in accordance to state inheritance law. So if you really want to get back at your children and don't want them to inherit or receive your assets, you need an estate plan. Don't not create a will, because if you don't, that's a surefire way that their children will receive your assets just by default on state law. Establishing your last will and testament is essential for every adult, regardless of the size of your estate. It guarantees your wishes will be honored and your assets will be handled as you envision after you've passed on. When you've properly prepared your estate plan, you could be confident that each heir will receive exactly what you want, whether you want to disinherit your kin or not. You need to iron out your wishes so that it is clear for everyone. Also, the most important thing to keep in mind when deciding to disinherit someone from your will is this: don't do it on your own. You can't just cross the name out through someone and write I hate this person and hope everyone will listen. That means nothing. No one will listen to that. And since you won't be there to answer questions, to defend your decisions, it's very important to follow the proper procedures and treat your will like a fragile legal document, and don't think you could just mock it up and that's fine. Make sure you consult with an attorney for the proper legal procedures for creating a will or revising a will in a codicil. So if you're out there and you're planning on disinheriting your children, you are not alone. There's plenty of well-known people who have made it explicitly known to their children that they intend to leave nothing to their children. Bill Gates is very vocal that most of his earnings will be donated to charity, and that's what he wishes his legacy to be. I believe George Lucas, same thing, the creator of Star Wars, who's a billionaire, who has the Star Wars franchise under his belt, says I think he donated 99%. Yes, I think it's George Lucas. So 99% of his estate will be donated to charity, and then his children get 10 million each, which is nothing to sneeze at. I mean, who wouldn't be happy with their parents leaving them $10 million? And there's some other few. Simon Cowell, he's the believer that everyone should work for their money, and he doesn't plan to leave anything to his child. But these people, I mean, even though they plan to leave nothing to their children can still have access and work off of the goodwill of the family name at the same time. So it's sort of they won't have billions of dollars per se, but they have access and resources just because of their family's connections. And who's going to close the door on George Lucas's son or daughter? So again, I wanted to lay this out. If you're thinking about disinheriting your children, or you know someone who is, there are some options available, and it's totally possible and legal to do. I hope this information has been helpful. I tried to make light out of a very serious subject. Hopefully you have some nuggets that you could take away from it and apply and share with anyone else you think will find value. Don't forget to like and subscribe, and let me know your thoughts. What do you think about parents disinheriting their children? Do you think they have the legal right to do it? Do you think Louisiana, the wild card, as I mentioned, is correct in reserving some of the estate to the rightful heir and not allowing our parent to totally disinherit the child? Or do you think the majority of states are in the right position to decide that no, you could totally disinherit your child? Let me know your thoughts, and I will see you next time. Bye-bye.